Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Khairul Fajr bin Aswadi. My metric number is 1201481. Inshallah, our group will present about illegitimate child. Enactment of Islamic Family Law (UUKI). The states in Malaysia aim to preserve the sanctity of the institution of marriage and the family of the Ummah Islam in this country. For example, marriage procedure, polygamous procedures, registration of marriage within and outside the country, and penalty for violating the provision. What's the legal definition of a child? A child is defined in Section 3 of the Distribution Act 1958 as a legitimate child, and where the deceased is permitted by his personal law. A plurality of wives includes a child by any such wives, but does not include an adopted child adopted under the provisions of the Adoption Act 1952 or the Adoption Ordinance of the State of Sarawak. A similar definition is seen in Section 3 of the Infested Association Ordinance 1960, which applies in the state of Sabah. What is the meaning of legitimate child? In simple terms, a legitimate child is a child born in wedlock or having been legitimated pursuant to the provision of the Illegetimacy Act 1961. For example, a child born out of wedlock can be legitimized through the subsequent marriage of his or her parents. Contradict with illegitimate child, the law defines an illegitimate child as a children born out of wedlock and was not legitimized pursuant to the provision of the Illegitimacy Act 1961. It is also stated in Section 2 of the Islamic Family Law Act 1984. Interpret that illegitimate in relation to a child means born out of wedlock, but not as a result of shubha intercourse. Conviction, lineage, or in Malay we call pensabitan nasab. In Islam, there are three main methods for determining the lineage, which is the first one is firash, marriage. Second is witness testimony, and the third is pledge. The first one is marriage. From Hadith Abu Hurairah radhiyallahu anhu, Rasulullah said, "Al-waladu lil farashi," which means that the child is for those who mix with their mother. That means a child from a legal marriage. From Riwayat Muslim 3598. The second is witness testimony, or what we call saksi. The type of testimony that can be determined lineage is two male witnesses or one male and two women in the opinion of Abu Hanifa and Muhammad. For Mazhab Maliki, it can be witnessed by only two men, while Imam Shafi'i, Hanbali and Abu Yusuf, it is witnessed by all his, which means it must be witnessed by all of the family members. The last one is pledge ikrar. Nasab through ikrar, a man's voluntarily confession to a child that he has a blood relationship with the child, whether the child is of extramarital status or the child is of unknown origin. Section 114. Condition for valid acknowledgement. Where a man acknowledges another, either expressly or impliedly, as his lawful child, the paternity of the child shall be established in the man if the following conditions are fulfilled. That is to say, the paternity of the child is not established in anyone else. The age of the man and the child are such that filial relationship is possible between them. Where the child is not discrete age, the child has acquiesced in the acknowledgement. The man and the mother of the child could have been lawfully joined in a marriage at the time of conception. The acknowledgement is not merely that he or she is his son, but that the child is his legitimate son. The man is competent to make a contract. The acknowledgement is with the strict intention of conferring the status of legitimacy. The acknowledgement is definite and the child is acknowledged to be the child of his body.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Abdul Hadi bin Abdul Ghani. My matric number is 1201465. And right now I'm gonna present the background facts of the case of Rosliza Ibrahim. The plaintiff is an illegitimate person, and that one Yap Ahmui Abadis is her natural mother. The word parents in paragraph B of the Interpretation of Muslim in section 2 of the Administration of the Religion of Islam, State of Selangor Enactment 2003, does not include the putative father of an illegitimate child. The plaintiff is not a person professing the religion of Islam. All laws made by the Legislative Assembly of the State of Selangor under the 9th Schedule, List 2, Item 1 of the Federal Constitution, FC, are not effect on and are inapplicable to the plaintiff. All Sharia courts within the State of Selangor do not have jurisdiction over the plaintiff. The plaintiff's birth certificate states that she was born at the Chinese Maternity Hospital, Kuala Lumpur, on 19 November 1981 to one Yap Ahmui and one Ibrahim bin Hassan. On 13 January 1994, Ibrahim submitted an application for an identity card on behalf of the plaintiff. In that application, Ibrahim stated the plaintiff's religion to be Islam. Ibrahim also recorded Yap Ahmui descent as Malay. A year later, on 14 January 1995, Ibrahim submitted an application for his new identity card. Ibrahim recorded his religion as Islam, and that he was married. Exactly a month later, that is on 14 February 1994, Yap Ahmui submitted her application for an identity card recording her religion as Buddha, her descent as Chinese, and her marital status as married. In all the applications for the identity cards, Ibrahim's address was the same as Yap Ahmui's address. On 8 October 2008, Yap Ahmui affirmed a statutory declaration, Yap Ahmui SD, to the fact that the plaintiff is her daughter, that Ibrahim and herself are the plaintiff's parents, and that Ibrahim and her were unmarried at the time the plaintiff was born, and lastly, that the plaintiff was not brought up as a Muslim. Yap Ahmui passed away on 7 February 2009. From these facts, the plaintiff claims that she is an illegitimate child. Thus, she argued that the religious status of her putative father cannot be regarded in the determination of her own religion, and because she does not adopt the religion of her father, and that she was never raised as a Muslim, she is not a person professing the religion of Islam, as per Item 1, List 2, 9th Schedule of the FC. The Land Judicial Commissioner dismissed the plaintiff's application on the grounds that she failed to prove her claim on a balance of probabilities. His Lordship strongly inferred, based on Ibrahim and Yap Ahmui's respective residential addresses and from their respective applications for their new identity cards stating married, that the two were married to each other. Accordingly, there was proof that the plaintiff was a Muslim, and hence her application to the High Court for these declarations was tantamount to her seeking to renounce Islam, a matter which is for the Sharia courts. The Court of Appeal agreed with the High Court. The Court of Appeal dismissed the appeal on a further ground that it was bound by the decision of the Federal Court, Illinois lawan Majelis Agama Islam, Wilayah Persekutuan dan lain-lain 2007.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Taufiq bin Ismail and my metric number is 1201469. Next, I will present to all of you about the court decision on Rosliza Ibrahim's case. Before we start, I want to remind to all of you that Rosliza's mother is a non-Muslim, which is she is a Buddhist, and her father is a Muslim. However, both of her parents were never married, so this makes her an illegitimate child. She wants the court to declare that she was never a Muslim and is not a Muslim, and Selangor state laws for Muslim do not apply to her, and that Selangor Sharia courts have no jurisdiction over her. Next, the court held that Rosliza Ibrahim is not a Muslim and never a Muslim. This is because the Chief Judge Tun Tengku Maimun Tuan Mat, who led a 9-judge panel in the judgment with a 7-2 majority decision, that allowed Rosliza Ibrahim's appeal and application. Rosliza Ibrahim's application is, she declared that she was never a Muslim and is not a Muslim, and that all Selangor state laws for Muslims do not apply to her, and that Selangor Sharia courts have no jurisdiction over her. Chief Judge also ruled that Rosliza was not a Muslim because there was no evidence that she was a Muslim, and he also ruled that Selangor state laws for Muslims do not apply to her, and that Selangor Sharia courts have no jurisdiction over her. Then, here is the reason why Rosliza was not a Muslim. Firstly, Selangor State Legal Advisor, which is Datuk Salim Soeb, who was appearing for the Selangor State Government, insisted that Rosliza was a Muslim when she was born. To justify his agreements, Salim cited Section 2 of the Administration of the Religion of Islam, State of Selangor Enactment 2003, where one of the definitions of Muslim was stated as being a person whose parents, either one or both parents, were a Muslim at the time of the person's birth, which means the definitions of Muslim is, if one of the parents is a Muslim, then the child of the parents is a Muslim. Next, Chief Justice Tun Tengku Maimun Tuan Mat, however, highlighted that the general principle under Islam is that a Muslim father and non-Muslim mother could not have been married because one of them is a non-Muslim, and that in such a case, the child who would under Islamic principles be born illegitimate and be unable to take on the Muslim father's religion but would follow the mother's religion. The Chief Judge also said that there was no evidence from Rosliza's father, religious authorities or other relevant persons. There was no evidence that Rosliza's parents were married. He also said that Rosliza is an illegitimate child and her mother never converted to Islam. Therefore, her father's religion cannot be inherited to her. Next, here is the reason that Selangor state laws for Muslims do not apply to her and that Selangor Sharia courts have no jurisdiction over her. The Chief Judge said, since the fact of the case showed that it was an ab initio case, that Rosliza from the beginning, based on the evidence, was not a Muslim, then the secular court or civil court has the jurisdiction in this case under the Federal Constitution. So this case does not need to be decided by the Sharia courts. In other words, Article 121 Clause 1A of the Federal Constitution does not apply in this case, which means Rosliza from the beginning was not a Muslim. So the Sharia court have no jurisdiction over her. In conclusion, Rosliza's mother is a non-Muslim and her father is a Muslim but were never married. This makes Rosliza is an illegitimate child. Rosliza cannot take on her father's religion because the general principle under Islam highlighted that a Muslim father and non-Muslim mother could not have been married because one of them is a non-Muslim, and that in such a case, the child would under Islamic principles be born illegitimate and be unable to take on the Muslim father's religion, but would follow the mother's religion. which means the illegitimate child religion would follow the mother's religion. That's all from us. Thank you for lending us your ears and have a great day. Assalamualaikum warahmatullahi wabarakatuh.